Good afternoon, everyone. I hope you can hear me. My name is Ingabire Françoise, and I'm from the Kigali International Arbitration Center, and I'm in charge of case management and capacity building. Today, I have the pleasure of moderating this session on the third-party funding as an avenue for increasing availability of arbitration and facilitating access to justice. So today we have a very experienced person, allow me to use that. He's an expert in dispute resolution, and he's going to be giving us some insight and sharing experiences on the topic. So we have Mr. John Ohaga, who is the managing partner in the leading law firm of the Triple Okelo LLP Advocates. Mr. Ohaga is an inspiration leader to everyone who knows him, and he's also widely recognized for his exemplary work and expertise in dispute resolution. Mr. Ohaga is a senior counsel. He's also a chartered arbitrator, and he was named as the Kenya's Law of the Year in 2020 in the 3rd edition of Nairobi Legal Awards in December 2020. And also he was also previously won the Pupil Master of the Year in 2019 as a recognition of his commitment and also the mentoring of the young lawyers. Mr. Ohaga has also been featured as one of the top 50 arbitrators in Africa by the Legal 500 in the arbitration power list and also the Africa Arbitration Academy. He's also been declared in 2010, 2016, 2017 as the winner of the Kenya in the category of litigation by the International Law Office Client Choice Award. Additionally, John Ohaga is also an accredited mediator and also a member of the Mediation Accreditation Committee. He's also the chairman of the Sports Dispute Tribunal, and also has been recently nominated as by the Republic of Kenya to the ICSID panel of arbitrators and mediators. Also has been nominated to the ICC Commission on Arbitration and ADR. So he's a trustee of the M-Pesa Foundation and who also sits on different boards in different companies. So please, participants, allow me to give the floor to Mr. Ohaga. And as you've seen, looking at his bio, you have to take your pen and also the notebook because we are going to learn a lot from him. So welcome, Mr. John Ohaga.
Thank you very much. And good afternoon, everybody. Let me start by saying what a privilege it is to be able to speak to everybody who is registered this afternoon. I also want to apologize if my voice quality is not as it should be. I'm struggling with a flu, but this is a topic that I really feel passionately about, and I thought that I would share my thoughts with you this afternoon. So thank you for taking your time to be here. We have 2 hours together, So I will try and spend about the first hour just talking through what I think are the salient aspects of third-party funding, what my thoughts are with respect to the costs of arbitration and how we can increase access to justice and thereby increase the uptake of arbitration. And then maybe we can spend the next hour with questions and with a discussion if you find the topic sufficiently vibrant. As I'm sure those of you who are arbitration practitioners know, the most cited objection to arbitration relates to costs. Costs are a significant factor because when you go to a state court, a municipal court, as a party, your cost of entry to the forum, so to speak, is really the court fees that you pay, as well as the amount that you pay to your advocate or your lawyers. When you have to go to arbitration, the costs, at least at the outset, are significantly higher because you have to pay your advocate. You also have to pay the arbitrator. Arbitrators, as you know, charge for their time. They charge on an hourly basis. I do know that some arbitrators charge an agreed amount or cap their fees. More and more arbitrators are becoming more creative about providing fee arrangements. But the reality is that there still is a barrier to arbitration as a result of costs. And yet arbitration offers so many advantages, both to corporate entities in the commercial sphere, as well as to individuals who are entering into commercial relationships or other relationships which would make themselves amenable to arbitration in the event of a dispute. And so we have to start to think about how it is that we, in this jurisdiction, as East Africans, can increase the uptake of arbitration. And what are the various forums or various mechanisms available to us? And one of the mechanisms that I think that is available that we can begin to give serious thought to is third-party funding. At the present time, of course, third-party funding is more prevalent in international commercial arbitration, as well as investment arbitration, but it generally is prevalent on the international platform because of the thresholds that third-party funders put with respect to the claims that they are prepared to fund. And they're prepared to fund claims of a certain amount because the returns, of course, in the event of success are quite attractive. But if you think that third-party funding can be made available on the basis of volume, number of potential users, number of potential claimants who would reach out to a third-party funder, then we can see that third-party funding can become viable within the domestic arbitration sphere, so that we can begin to think about regulation, we can begin to think about statutory reform to enable, for instance, microfinance companies, to enable fintechs, to enable banks to enter the field of dispute resolution by funding the disputes that arise and profiting therefrom, and therefore making this really something that is a commercially vibrant and available to more people than at present are able to access arbitration. But the first thing that we have to ask ourselves, as always as lawyers, is what is third-party funding? Now, if you as a lawyer have taken on a case on a contingency basis, for instance, you're a third-party funder because you're essentially funding the that dispute. You're essentially funding your client up to the point where hopefully there is an award, and hopefully you can repay yourself from that award and hopefully make an amount that would be significantly more than you might earn if you just charge a fee. So there are numerous facets of third-party funding, but essentially, a third-party funding is a mechanism by which a third party, that is somebody that is not one of the disputants, agrees to step in and to provide the funding to enable a claimant, and in some instances, a respondent who perhaps has a counterclaim to be able to access the forum and to be able to agitate their claim, hopefully successfully. There have been numerous attempts to define third-party funding, but because of the number of models of third-party funding, it is really difficult to find one definition that fits every situation. But we can say that third-party funding is a financing method in which an entity that is not a party to a particular dispute funds another party's legal fees or pays an order, an award, or judgment rendered against that party, or both, and also meets the costs of the forum, in this case, the arbitrator. As you probably know, as lawyers who practice both litigation and arbitration, third-party funding is already common in litigation. In fact, it is very widely used in personal injury cases. And I'm certain that those of you who have participated in personal injury litigation will already have experienced some facet or the other of third-party funding. Whether it is you as counsel providing the funding by withholding the charging of your fee until the end of the claim, or by finding some other way in which to facilitate your client, that is third-party funding. In international arbitration, there are specialist companies which are set up for that express purpose of meeting the claimant's legal fees, supporting the arbitration, supporting counsel, and at the end, hopefully being able to gain an uptake of up to 50% actually of the amount that is recovered. Now, the funding can be provided at any point during the arbitration, but it would typically, a prudent third-party funder would want to provide funding at the commencement of the arbitration. And there are reasons why, which I will go into, why a third-party funder would want to be involved from the outset. In the more, shall I say, developed jurisdictions such as the UK, for instance, and Philip Halik, I see you here. Perhaps you could share your thoughts on this at some stage. Third-party funding has grown exponentially, and there are investment funds which are willing to invest in both litigation and arbitration, either by directly pumping in money or providing insurance packages which allow parties to enter the fray, so to speak, participate in the dispute effectively, and hopefully succeed and make money both for the claimant who is seeking compensation for a breach or some for the injury occasioned arising from the relationship, and for the funder who essentially invests in the dispute. Now, in order to understand why the third-party funding is an issue that we need to talk about, and it is an issue which requires statutory reform as well as regulation. We do need to have some insight into the history of third-party funding and why third-party funding has previously been frowned upon, because that has its roots, shall I say, in medieval times. Now, third-party funding essentially involves intermeddling in other people's disputes. In ancient Greece, in ancient Rome, in medieval England, there were doctrines of maintenance and champerties. And the prohibition of intermeddling, therefore, was rooted in the public policy rationale, which said that in order to protect the integrity of the justice system and to protect weak parties from oppression by more powerful parties, it was not allowed to fund parties or to foment disputes, so to speak, because fomenting disputes was frowned upon because it was seen as encouraging vexatious litigation, seen as encouraging disputants who might otherwise not be able to maintain their grievances, but also seen as enabling those who could afford it to profit from other people's disputes. But over a period of time, and as we have come into modern ages, public policy has shifted, and the rationale has now disappeared. I think you will find that we now have a sufficiently robust justice system that cannot be manipulated. We have more sophisticated people entering into commercial relationships and therefore becoming disputants and therefore able to negotiate their own bargains. And so the whole objection to champerties, to maintenance, to the question of intermeddling is one which has faded into the background. And I dare say now that when we look at various provisions of law, for instance, the Advocates Act in Kenya, other legislation that govern the legal profession in our different jurisdictions, and which prohibit or continue to prohibit maintenance and champerties, are provisions that actually are outdated. There are provisions that as law reformers, we need to look at again and to recognize that they actually are an impediment to the constitutional imperative that requires that there be access to justice for all. And so we need to open up the doorways of the courthouse or the arbitration forum. And if that means enabling persons who can fund to be able to enter into that arena, then that is something that I strongly feel and believe we should encourage. And we should lobby our respective legislation or legislatures to be able to make that available. Now, why is that the case? That is because there are advantages, as I've said, to be gained from being able to access funding by third parties who are willing to provide it. The headline for me there is, as I've said, and is as part of the topic of our discussion today, access to justice. And it is access to justice because claimants who would otherwise not be able to afford arbitration would now have access to that recourse. And this is beneficial, especially in terms of economic uncertainty, when financial resources to fund expensive arbitration might not be available. In Kenya now, as you know, we have the hustler economy, and obviously this would contribute greatly to the economic philosophy that our new government has brought into place. There might be other reasons for Tanzania, for Rwanda, for Uganda, but access to justice remains the headline. Funding provides both financial and operational support because it provides a mechanism through which the claimant can share with the funder both the financial and the operational risks that come with pursuing claims of this nature. An experienced funder will be able to add value to the arbitration in the form of management support by assisting the lawyer, by assisting the claimant in carrying out, for instance, due diligence, in carrying out investigations at various stages of the arbitration, and generally in being able to meet the milestone fee notes that arbitrators churn out from time to time and keep the arbitration churning over. It also is, I think, useful for the arbitration community because it enables us to grow a strong community of arbitrators who are able to handle both large and smaller arbitrations in the knowledge that they can essentially be specialist arbitrators and that they can form a full-time profession as arbitrators because third-party funders will enable us to grow the foundation or the volumes that we require to keep arbitration vibrant and to keep it as a viable alternative to litigation. Now, there are obviously disadvantages to third-party funding, and we do need to talk about those, and we do need to have our eyes open when we talk about third-party funding. The first disadvantage is, of course, the power of the lender or the funder. Essentially, when a third-party funder enters the fray and agrees to fund an arbitration or even a litigation, any sort of dispute, by virtue of the fact that you're funding, you have a significant say in the dispute, in the strategy to be adopted, in the lawyers to be employed, in the way that the claim is to be structured, and so on and so forth. So how do we ensure that we have a robust regulatory framework that ensures that the funder's place is recognized but regulated, so that the funder does not abuse the commercial relationship that it enters into with the party that is being funded? The second thing is that the presence of a third-party funder will certainly alter the dynamics of the arbitration and may actually make it more difficult to resolve that dispute amicably. Because once a third-party funder enters into the arena, they immediately have a stake and they have an expectation that they will reap a reward. As I said, some funders will charge a premium of up to 50% of the potential awards that may be rendered. Now, that becomes a disincentive to an amicable resolution of the dispute, because an amicable resolution of the dispute necessarily means that a claimant is willing to accept less than it has claimed, and that obviously means that the third-party funder may not be able to recover the amount that it projected it may be able to recover if the claim went to full hearing. So once again, that potential downside is one that we must recognize. Does it also open the doorway to vexatious claimants who may not otherwise have viable claims? That is something that has been cited. In my view, the fact that a third-party funder audits the claim, so to speak, and is willing to put in their money in order to fund the claim, essentially negates the potential disadvantage of having vexatious claimants. Because a vexatious claim is one that, in all likelihood, there's no chance of success. A funder is unlikely to take up a claim that has no chance of success, because it is essentially investing in the claim. So I would really not, I don't think that the presence of funders would lead to an upsurge in claims by vexatious claimants. But there are other disadvantages that we must be aware of. There is, of course, the alteration in the dynamics of the relationship between the parties when a funder comes into the arena. This is caused by the fact that it affects the party autonomy that we have generally cited as one of the cornerstones of arbitration. One of the cornerstones of arbitration, which is cited as as party autonomy, really relates to the fact of the parties being in control of the way in which their dispute is structured, the way in which they agree to appoint an arbitrator, and the way in which they formulate the rules of engagement in arbitration, and so on and so forth. A funder necessarily breaches, so to speak, the confidentiality that exists between parties, because in order for a funder to be able to audit the potential for success of the claim, the funder must have access to the entire relationship between the parties. They must have access to the contract, must have access to the correspondence exchange between the parties, must have access to the history of the relationship between the parties, and will necessarily want a say in the appointment of the arbitrator, as I've said before, perhaps even in the appointment of the lawyers or the legal counsel retained to handle the claim on behalf of the claimant. And so the funder essentially becomes like another party to the dispute. This is essentially why they're called a third-party funder, because they are a third party in the dispute and are funding the dispute, and therefore a very important player in that dispute. That then brings with it other disadvantages or other potential gray areas which we need to also be aware of. The next one is conflict of interest. And conflict of interest arises because, as you know, arbitration allows a practicing advocate like myself, who at once can represent clients in arbitration and in other dispute resolution fora, but also in advising clients, but can also sit as arbitrator. So potentially, I could be appointed an arbitrator in a dispute in which the third-party funder is actually my client. And so the third-party funder may have access to the arbitrator, and at the same time have an interest in the claim over which the arbitrator has been asked to preside. That means, therefore, that potential regulations, when we start to think about regulating this area, must give thought to the question whether parties who are being funded must disclose the facts that they are being funded, must disclose the identity of the funder, and must disclose certain aspects of the funding that they are receiving, so that both the tribunal as well as the respondent have a clear visibility as to who they are dealing with, as the claimant as well as the funder. This therefore allows the arbitrator as well to be able to make a full disclosure, because the arbitrator now has visibility of all the players in the dispute. Absent such disclosure, we will find that that potentially an award could be set aside or could be challenged or impeached if a respondent discovers very late in the course of the arbitration that in fact the impartiality and independence of the tribunal, which as you know is fundamental to arbitration, was absent. And was absent because the arbitrator did not have the opportunity to make disclosure, or the third-party funder has somehow entered into a relationship with the arbitrator geared towards influencing the arbitration in favor of the claimant. So the arbitrator must be able to remain independent and free of influence of the parties from the outset, from the commencement of the arbitration, and throughout the entire proceedings. And this is a principle that I'm sure that you are all very well aware of. So that becomes then another aspect that we do need to be aware of. The other aspect relates to legal privilege. And I've spoken about confidentiality. Before entering into a funding agreement or a funding arrangement, the funder will want to undertake a very thorough due diligence process. This means that both the party as well as the counsel retained for the claimant in most cases will have to provide the third-party funder with access to the information relating to the dispute. As I've already said, this necessarily breaches the confidentiality of the parties, as well as, of course, the legal privilege that exists between counsel and party, and which then becomes something that we have to give consideration to when we speak about legal privilege, when we speak about the cornerstones of that we traditionally know guide the way in which we relate as counsel, the way that we relate with a tribunal or with any forum that we have put in place to resolve the disputes that we enter into. So, as lawyers who are potentially going to be involved in advising a party who is entering into a relationship with a third-party funder, there are various things that we need to have in consideration, because we also need to be able to carry out a due diligence on the third-party funder that our client is entering into a relationship with. This is because the funder must be able to meet the liabilities under the funding arrangement from the commencement of the arbitration through to the eventual outcome, which includes the costs involved in obtaining the award, as well as the potential costs if the claimant loses. Because you can see the difficulty that would arise where a funder, has undertaken to fund a claim, but is not prepared to meet the adverse costs that may be awarded to a respondent in the event that the respondent is successful in resisting the claim. So that means essentially that to a significant extent, and more it is becoming the norm that an arbitral tribunal must have some superintendence over the third-party funder, to the extent that the tribunal must be able, having had visibility of facets of the third-party funding agreement, having had knowledge that a party is being funded, the tribunal must be able to make a costs order that reaches beyond the funded party and that also compels the funder to meet the costs of the arbitration in the event of an adverse award. And that also means, therefore, that the respondent must be able to reach beyond the claimant and compel the funder to meet those costs. You know, ipso facto, it follows that if a party is having to engage a funder to meet its costs, both operational and legal, in running through an arbitration, it necessarily means that that party is either impecunious or does not have the means to be able to meet its costs. Ordinarily, you and I would apply for security for costs and would not enter into that dispute without a safeguard of such security for costs. So a third-party funder, therefore, essentially becomes the party that guarantees that those costs would be met. And this becomes a complication that tribunals will have to be able to grapple with, because it essentially means that as a tribunal or as a sole arbitrator, how do you deal with a party that is not a direct party to the dispute? Again, this will call for regulation, this will call for critical thought, this will call for legislative reform. Now, we also need to be able to advise our clients as to the structure of the funding agreement in order to be able to negotiate appropriate terms for our clients. When you speak about a 50% return to the funder, it does appear to be a very, very significant amount. But as counsel, as legal advisors, I'm sure that there are ways in which we can advise our clients as to what is a proper return for a funder, so that clients who are looking to third-party funders are not taken advantage of. We must also be able to ensure that the funding agreement is well structured and that they limit the potential for the funder to exert both economic power as well as other influence over the client, so that there are clear termination rights and that there are clear management responsibilities that are set out as between the funder and the party and its legal advisors. Of course, we must also conduct a conflicts check to ensure that we are not entering into a relationship with a funder that could potentially be conflicted, either because it also has a relationship with the respondent or has had a previous relationship with the respondent, or has some other relationship that otherwise impedes its ability to be able to come through with the funding arrangement in the best interests of your clients. There are other practical considerations that we will need to think about and that are worth noting. Now, I started off by saying, or the headline topic today is how we can utilize third-party funding as African or East African jurisdictions in order to make access to justice available to our clients, in order to enable our clients to realize the potential recourse or compensation that comes from pursuing a successful claim. Having given consideration to different jurisdictions in Africa, I found that third-party funding is actually in existence and vibrant in South Africa. In South Africa, in fact, there already exists several funders and it is actually an active area of practice and a commercial venture that is available in South Africa. This is, of course, both with arbitration and litigation, and arbitration is borrowing very heavily from litigation. Nigeria, as you might know, has also recently reformed its arbitration legislation, even though it has not yet received complete legislative assent. But Nigeria has recognized that third-party funding is something that needs to be provided for, and the new Nigerian arbitration legislation does provide. It is called the Arbitration and Conciliation Act, Amendment Bill of Nigeria, does provide for third-party funding. Kenya has not yet reformed its Advocates Act. Kenya has also not yet reformed its Arbitration Act. I can tell you that as chair of the committee that had been appointed by the Attorney General to look into legislative reform of the entire ADR environment in Kenya, there are various legislative provisions that we had considered and had recommended for reform. Third-party funding is not one of them. If my term and my mandate was to be renewed today, certainly third-party funding would be something that I would give very, very serious consideration to. And I would give serious consideration to it because I strongly believe that with the momentum given to arbitration and to ADR by Article 159 of our Constitution, which requires the judiciary now to promote arbitration and other forms of ADR, it necessarily means that statutes must begin to fall into place and begin to have provisions that lend themselves to promoting arbitration and ADR in compliance with the constitutional imperative. In addition, you do know that in Kenya, the Constitution also has, under Article 48, a provision relating to access to justice for all persons. And so therefore, the arguments that are potentially or would potentially be raised relating to sharing of profits, to sharing of, prohibiting charm parties and maintenance, and the other prohibitions that exist in the Advocates Act against advocates sharing fees with unqualified persons, I think are archaic provisions. They no longer belong in the Advocates Act, and I would suggest the same for the other legislative provisions in Uganda, in Tanzania, in Rwanda, which have similar provisions. In South Africa, the courts have been called upon to give consideration and to pronounce themselves on third-party funding. And there are numerous cases now in South Africa dealing with arguments relating to prohibitions to charm parties and third-party funding, and the whole question around public policy and the rationale around the arguments that third-party funding could potentially have a negative impact on the provisions relating to fair hearing. In fact, the South African courts have come to the conclusion that the courts themselves are sufficiently sophisticated to be able to put in place safeguards that ensure that a party, whether funded or not, has access to the courts and that judges are well placed, properly educated to be able to ensure that they are not unduly affected by the power imbalance that you might find between a party that is funded and one that is not funded. And in fact, as I've said at the outset, there are already many facets of third-party funding, which the courts may not be aware of. Those include contingency fee agreements that advocates regularly enter into. And so, if we are going to move forward, if we are going to reform our entire arbitration environment, if we are going to make arbitration as widely available as possible, both to sophisticated corporates as well as to the ordinary person who wants to be able to access both our state courts as well as our arbitral forums, but do not have the wherewithal to do that. And if we are going to allow the growth of third-party funding as a commercial initiative, then we must think about all these reforms. There are numerous reforms that have taken place in the UK, for instance, in Hong Kong and Singapore, in South Africa, in Australia, all of which are geared towards ensuring that the ethical areas or ethical barriers that arise in relation to third-party funding have been addressed and no longer an impediment. I think I will stop there in order to allow us to engage in a discussion around this topic, so that you can also put forward your views and express the question whether there should be legislative reform, the nature of reform that we need to enter into, and whether there should be uniform reform across our different jurisdictions. Because as you know, as arbitrators, we are available to practice across jurisdictions, as long as you have the expertise that the parties require. And so, as an arbitrator, you want to be able to find that you have the same practices, whether you're appointed by KIAC in Rwanda, whether you are appointed by MIAC in Mauritius, whether you're appointed in Uganda, or whoever the appointing authority is, whatever the nature or identity of the parties, you want to be able to go into an environment which is familiar, an environment in which you know the rules of engagement, and you know that you are available to all the parties. And so I would commend to you third-party funding. I would commend to you I would commend to you to be champions in your different, shall I say, in your different environments. I beg your pardon. I'm running out of gas now. And I'm very, very happy to engage with each one of you in your different arenas, to be able to think through this more clearly and to be able to lead the charge towards opening up arbitration to our people. So thank you very much. Thank you for your attention. And I'm very happy to take questions, comments, and other areas of discussion. Thank you.
Thank you very much, sir, for this comprehensive presentation. And as you mentioned, I think third-party funding is something that has to be considered, because I'll give an example of maybe at KIAC, where you have a party, and then they will say that they have a dispute with a certain person, but the problem will be that they don't have enough funds to proceed with the case. And it's not something that is really good when someone has a problem and then they don't have how to solve it. So speaking of that, maybe to understand more about the advantage of the third-party funding. So to what extent the third-party funding goes to? For example, you have a third-party funding and you had a case in Rwanda, and the award has to be enforced maybe in the UK. So do third-party funding go to that extent, to even to the award enforcement, or just it has an extent to just reach? Yeah, thank you. That was my question, and we welcome also others to send the questions. We already have some. Maybe after my answer, you can direct you and go through the questions. Thank you.
Thank you very much for that question. And I can see other questions in the chat box. But just to deal with your question firstly, you know, a third-party funder will only agree to fund if the funder thinks that an award can be enforced successfully and effectively and efficiently. That means, therefore, that the third-party funders want to come into an environment, into a jurisdiction, which facilitates, or which has proper legislative framework, as well as a judicial environment which lends itself to arbitration and which allows the third-party funder to engage with the claimant until there's been successful enforcement. The third-party funder recovers its money from the award. Essentially, a third-party funder funds on the basis that there will be an award and on the basis that the claimant agrees to pay a proportion of the award. So a third-party funder who, for instance, funds a party who has a claim for, say, $1 million, may very well say to the claimant, you have a claim for $1 million. I am prepared to fund you whatever it costs, providing you pay me 30% of the amount that you recover, or 30% of the award. So 30% of $1 million would presumably be what, $300,000? So that would be the amount. So assuming the funder has spent $100,000 in funding the claim, then the funder has a $200,000 US profit. The funder is there to profit from that enterprise. It is an enterprise for the funder. It is not some academic engagement. So whether the award is to be enforced in the UK or in Ukraine or in Uganda, or wherever it is, the funder is very, very interested in where the assets of the respondent are, in what the environment, the legal environment where the award may potentially be enforced is, what the ease of enforcement may be, and whether or not it will, in fact, eventually recover the award. So the funder is essentially investing in the claim. And that's really, when you understand that the funder is investing in a claim, you will understand that the funder has an interest, not just in the merits of the claim, but also in the identity of the respondent. There is no point pursuing or funding a claim against a respondent that is impecunious, against a respondent that has no assets. There is also no point of a funder funding a claim against a respondent who is in a jurisdiction where recovery may be difficult, where the legal environment is uncertain, where the judiciary is an impediment to enforcement, and so on and so forth. So the funder is interested not just in the merits of the claim, as I've said, is interested in the forum, is interested in the arbitrator, is interested in the respondent, is interested in the environment in which the respondent operates, is interested in is everything around the claim. So third-party funding has the potential, therefore, you can see, to ensure that we have a much more vibrant arbitration environment, because it will improve the environment in which we participate in arbitration, in all aspects of that environment.
Okay.
So who qualifies to be a third-party funder? If there is going to be regulation, I would suggest that there should be regulations around who qualifies to be a third-party funder. So if a microfinance institution wants to undertake or wants to enter into third-party funding, then there should be regulations around the entry into that environment. There should be some way in which you can vet that funder. There should be some way in which we can assess whether that funder, in fact, has the necessary funds to fund claims, how many claims it can fund at any one time, and so on and so forth. So that would be part of regulating that environment. I see so many other questions in the chat box, but Francois, perhaps you can guide us through the questions so that I can try and answer them, and maybe invite other comments from other participants.
Sure. So there is this question from Felix Omondi. He asks, while third funding sounds like a good idea insofar as it will facilitate access to justice, how accurate is it to say that the entry of the funder or financier will in fact give a financial face to the dispute?
Well, as I've said, the third-party funder is an investor. If you think about an investor in any forum, an investor investing into anything, if you think about an investor that agrees to support an entrepreneur who wants to put up a shopping mall, for instance, there are numerous benefits that come from the entry into that arena by the investor. It means that there is employment is spurred because entities will take up space in that shopping mall. It means that there will be outlets that are assessing that shopping mall as to whether or not it is a convenient location. The vibrancy of that environment increases because of the shopping mall. And I say this because I compare that with a third-party funder entering into a dispute resolution process. The advocates for the claimant will be paid. The arbitrator will be paid. The stenographer will get paid. The tribunal secretary will get paid. The respondent, of course, has to engage counsel and pay counsel to defend them in that dispute, in the defense of that dispute. It means, therefore, that the entry of the third-party funder brings a vibrancy to that arbitration environment. And that's what I'm talking about. I'm talking about the commercialization of dispute resolution and making dispute resolution a commercially vibrant environment, not just for advocates, but also for the parties who enter into relationships, and also for everybody else involved. If you are arbitrating under the rules of a particular institution, if it is KIAC, the administrative costs of that institution will be paid. And so the entry of a third-party funder is one that has advantages that I think you can compare with the entry of any entrepreneur into any space, whether it is a housing development, whether it is a shopping mall, as I've said, whether it is an office block. If you think about it that way, then you begin to understand why it is that I think that third-party funding is attractive from our perspective as lawyers. But as I've said, there is also a downside, and that downside requires regulation. Once we recognize what the downside is or the potential pitfalls are, then we know what regulatory environment we need to put in place. This is not rocket science. There are many, many people who have gone ahead of us. And so there are many jurisdictions that we can borrow from who have a vibrant arbitration environment and who we can say have shown the way. And so I would commend various other jurisdictions from which we can borrow from. But the first step is to reform our own legislative environment in order to make it attractive, in order to make it available for funders to come into the environment, for funders to come into these jurisdictions, and for funders to recognize that, in fact, there is potential for them to earn a living or to make a return by participating as funders.
Okay, thank you.
I hope
So
that
there's
answers that question. Yes.
There's also Martin Mugaro again. He's asking, is there a specific instrument to be used that binds third-party funder to the arbitral proceedings or a party being funded?
Yes, the answer is of course yes. Now, in the same way that you would enter into a loan agreement as a lender and a borrower, a claimant or a party to a dispute that is in arbitration who is funded by a third-party funder must enter into an agreement. The only thing that you need to understand is, from the perspective of the claimant, the funder cannot have recourse against the claimant in the event that the claim is unsuccessful. So to that extent, the claimant is protected in its relationship with the funder, because the funder cannot stand back to the claimant and require the claimant to refund the amounts that have been paid in facilitating the claimant through that whole arbitration journey. However, there is another party to the arbitration, or there are other parties to the arbitration. Those parties include the arbitral tribunal and include the respondent. And this is why I say that there needs to be disclosure at the outset that a claimant is funded, so that the arbitral tribunal can regulate the relationship between itself, the claimant, the respondent, and the funder. Because if the respondent has no recourse against the funder, then it means that the respondent potentially could walk away without being able to recover an adverse order of costs against the claimant. So there needs to be some mechanism by which the third-party funder is made responsible or liable for the costs incurred through the arbitral process. And that's something that we need to think about, that we need to put in place. And that is the instrument that an arbitral tribunal needs to fashion. So there does need to be an instrument between the claimant and the funder, and then a separate instrument or other mechanism by which the funder relates with the tribunal and the respondent. And that is an innovation that needs to come into place. Now, so Nana then asks, yes, sorry, carry on, Francois.
Yeah. So there are some other participants who raised their hands. So yes. I think I should go ahead and Carol Mutai. Hello? Hello? Oh, okay. There is also Stephen Kalinda. He has also raised his hands. Hi, Stephen. Hello? I think, can you hear me? Hello? Well, I think maybe they can't hear me, so maybe we can proceed in the chat room.
Yep.
So there is a question from Nana. She's asking, what happens when the funded party in arbitration wants to engage in settlement with the respondent? How does funder recover its money in such scenario?
Yes, that's an interesting one. And as I say, that's one of the potential disadvantages of the entry of a third-party funder. Ordinarily, the agreement between a third-party funder and the claimant will require the claimant to consult with the third-party funder in relation to most important decisions around the arbitration. And that will include a decision as to whether or not to settle. Now, you will appreciate that a third-party funder has essentially negotiated a return on its investment. Now, if the potential settlement gives the third-party funder a less than adequate return, then the third-party funder may not be attracted to the settlement, which means therefore that there would be a disincentive for the claimant to settle with the respondent. So it might therefore have a chilling effect on settlements, because if a settlement is below a certain amount or the amount anticipated by the third-party funder, the claimant may be in breach of its agreement with the third-party funder if it agrees to settle at an amount less than the threshold agreed with the third-party funder. So in that case, the funder may very well say that it must therefore have recourse to the claimant for its money. Now, there are of course scenarios in which a claimant and a respondent may want to settle their dispute outside of the forum. And that essentially means that it is possible for a claimant and a respondent to secretly settle the dispute to the exclusion of the third-party funder, which means the third-party funder has no way to recover its claim. That would mean that the claimant is in breach of its agreement with the third-party funder, which would lead to another dispute because the funder would now have a claim against the claimant. I would anticipate that any properly constructed third-party funding agreement would preclude a claimant from entering into a settlement arrangement without the consent of the third-party funder. And in any event, any such third party, in any such settlement would have to make provision for the costs or for the for recovery by the third party funder of its claim. So all these are matters for contract between the third party funder and the claimant, which means, of course, this is why third party funders also have their own lawyers scrutinizing the arbitration agreement, scrutinizing the way in which the arbitration is conducted, constructing the agreement between the funder and the claimant, and so on and so forth, to ensure that the third-party funder is protected in that situation and is able to recover its money in the event of a settlement. I hope none of that answers your question sufficiently.
Okay. Thank you. Participants, we encourage you to raise your hands should you need to ask a question or give an input. I can see Stephen has raised his hand again. Stephen, can you hear us?
Hello.
Yes, good afternoon.
Yes, good afternoon, Fanny.
Yes, please go ahead and ask your question.
Okay, thank you so much. I'd like to take this opportunity to thank Council John for a nice presentation. This topic is too new to us, some of us, though it is so interesting. So my question goes like, what is the right of the defendant in terms of right to privacy? Because you see many cases of arbitrations, it requires a lot of privacy that someone may even prefer to go to arbitration because of they don't want to hear their case in public. So now here we are seeing another party coming in who has just come to fund the proceedings. So I'm asking, what would be the rights of the defendant? Does he have right also not to accept, or I just want counsel to clarify me about that.
Yes, thank you very much, Stephen. That's actually a very interesting question. When parties enter into a relationship in which arbitration is the designated dispute resolution methodology or mechanism, of course, there is an expectation that there will be a certain amount of confidentiality, that they will be able to resolve their disputes in a private environment without intrusion and without inviting other parties to that dispute. And so that certainly is something that needs to be given consideration. The reality is that third-party funding breaches that confidentiality between the two parties because the third-party funder will necessarily, as I said, have to have access to the history and to the documentary chronology of the relationship between the parties. So I suppose the question that you ask, therefore, Stephen, is whether a respondent can preclude a claimant from entering into a third-party funding arrangement because of the breach of confidentiality or in order to safeguard the privacy of the respondent. I would say theoretically, yes. Practically, probably not. I say practically, probably not, because we can either have a situation where a claimant is funded, but is funded secretly and therefore privately and therefore the respondent has no knowledge of the existence of the funder and is therefore not aware that there is a potential breach of that confidentiality. The moment parties enter into a contractual relationship where arbitration is a mechanism for dispute resolution, you must expect that there will be some breach of confidentiality at some point. There may be a breach, for instance, if a party goes to litigation in breach of the arbitration agreement. That means that the respondent has to essentially obtain a stay of the proceedings in order to track back that dispute to the right forum. There is already a breach because that dispute is in the public domain because a party filed it in a public forum, which is a state court, which is a municipal court. There is also a potential breach because of the number of parties that are invited into the arbitration arena once an arbitration commences. And that includes the tribunal, that includes the advocates for both parties, that includes all the players in the arbitration forum. It's eventually the award must be enforced. In order to be enforced, if a party does not comply voluntarily, that award will have to be enforced in the manner in which you know that awards are enforced, by recognition through our courts. Again, potentially that dispute then comes into the public domain. So the question that I think we ask ourselves is, are we better off recognizing the existence of a third-party funder and therefore moderating the relationship between the claimant and the third-party funder, between the third-party funder and the tribunal, and the obligation of the third-party funder to the respondent? Or do we want to continue to have claimants who are funded in secret? Or do we want an environment in which claimants can be funded secretly and therefore cannot be regulated? It seems to me that in the interest of transparency and regulation, it is better that we accept some form of breach of confidentiality, some breach of the privacy of the respondent in order to be able to regulate the relationship. So we recognize that there is a breach of privacy, but that it is better that that breach it is better that we allow the breach and then regulate the relationship. Because I think that in the fullness of time, we will find that third-party funding is something that is with us in another 3, 4, 5 years, 7 years. So we should start to think about it. We should start to think about the pitfalls and talk about things such as what you mentioned here, Stephen, and then think about regulation. So I accept your point, but I also think that overall, that confidentiality, that breach of privacy is one that we must accept anyway if we are going to go forward with third-party funding. I hope that helps.
All right, thank you. Right to the next question from Wycliffe. He says, thank you very much, SC. As you may understand, obtaining consensus from all the ESC partners to amend their concerned laws to accommodate third-party funding may take quite a period. How about moving the ESC concerned organ, example, trade committee? He says he's not familiar with the organs, to come up with an instrument from which all partners of the ESC will pick and have them implemented in their respective jurisdiction. Actually, this is an input, not a question. Also, we have another question.
Francois, if you just allow me to comment on that first.
Yes, yes.
I think that's a really brilliant suggestion. I think it is a really forward-thinking suggestion, because it is one that enables us to move together as jurisdictions within the East African community, and to have one repository, so to speak, for reform in this area. And I think lobbying the East African partners through the instruments that Steve Wycliffe suggests is something that I really would be open to. And I think I would actually commend even to the East African Law Society as something that should be taken up, so that we have one common agenda, one common lobby group that allows us to drive forward our agreement relating to the attraction and availability of this third-party funding. So thank you very much for that suggestion, Wycliffe. I think it is really a really progressive suggestion. Thank you.
All right. There's also another input before I go to Joy's question from Philip Alika. He says, thank you very much for your comprehensive seminar. Third-party funding is a hot topic which is receiving considerable attention. Sorry, I am scrolling. Third-party funding has been identified as a hot topic in the UNICITRAL working. Sorry, I'm scrolling down. Yeah, he says the third-party funding has been identified as a hot topic in the UNICITRAL Working Group 3 on investor settlement dispute, where he says he sits. Attendees may find it, it's a long message, that is why I'm taking two. Okay, attendees may find it informative to look at the material on the UNICITRAL and ICA websites. Many of the issues which you have explained so well, conflicts of interest, privilege, confidentiality, disclosure, equality of arms after the event, insurance, security for cost, choice of counsel are discussed. As you mentioned, third-party funding is not now considered contrary to public policy in England and many other, sorry. I think he says many other jurisdictions. Sorry, because the message is quite.
Yes, I can read it. Yeah.
Exactly. Yeah.
Yes,
Many other jurisdictions.
Thanks, Philip. I think he says is in a hearing, so perhaps unable to continue with us. But yeah, that's really useful. I think, as he says, it is a hot topic now in international arbitration. Both investment and commercial arbitration. The issue is how can we make it relevant to our domestic environment? And this is what I'm talking about. So if you use the resources that Philip has put out there, you can educate yourselves more on the question of third-party funding, and we can then be able to move together in ensuring that in our specific jurisdictions, we determine how to incorporate third-party funding in our respective practices. So thank you very much, Philip.
Okay, thank you. So back to Joel's Mogesi questions. he's saying there is the general argument that the doctrines of carpentry and maintenance are specifically and traditionally only limited to litigation. As such, the position by some commentators has been that absent an express prohibition against third-party funding and arbitration, legislations allow application of third-party funding in arbitration. How correct is this position? In any case, if it's correct, given that enforcement of arbitral awards is done in national courts, does the general position then in litigation affect the enforcement of the third-party funding agreement?
Yes, Joel, I think you you really have hit the nail on the head. We must make a distinction between litigation and arbitration. Arbitration is a consensual dispute resolution process between parties who agree to go to arbitration. And so therefore arbitration is conducted or carried out in a forum which is outside a state court. However, the problem is the question whether public policy objections to champerties and the maintenance that presently exist in litigation would be imported into arbitration, precisely for the reason that you mentioned, which is that enforcement of awards takes place in national courts. Now, I see no difficulty where a respondent agrees voluntarily to honor an award. So where there's an award against a respondent and the respondent agrees to pay up, there's no problem, because then the claimant then pays off the third-party funder, and the matter remains between the parties. The problem is that when you have to go to enforcement in a state or municipal court, then the tenets or the objections that are prevalent in litigation find their way into the arbitral process. As you already know, there are many elements of litigation which find their way into arbitration once you enter into a state court at whatever stage, whether you are challenging the independence of an arbitrator, whether it is a challenge to an arbitrator's finding on jurisdiction, whether you're looking for support from a national court with respect to enforcement of interim measures. And of course, finally, when you come to enforcement of the award, you do know that public policy considerations are one of the relevant considerations that the court would have faced with either an application to set aside or an application to recognize and enforce an award. So therefore, recognizing that public policy becomes relevant at that point, we have to ask ourselves the question, do public policy objections that exist in litigation become relevant and become an impediment to enforcement of an award arising from an arbitration tribunal? Is it available to a respondent who is seeking to resist enforcement to cite the fact that a claimant is funded and that a claimant has therefore agreed to share the proceeds with a party that was not party to the arbitration or a direct party to the arbitration? Is that potentially an objection to the enforcement of an award? And the problem is that it is untested in many jurisdictions. we have found in many jurisdictions that the approach of our courts can be very, very uncertain, can be very unpredictable. And so rather than enter into a third-party funding arrangement in such an unpredictable environment, isn't it better that we deal with it through legislation and regulation so that it becomes clear that there is no more public policy objection to third-party funding, that champati and maintenance are not available as public policy objections to arbitration, so that it does not become an objection or a potential impediment to enforcement of an award. Because in the end, if you cannot enforce your award, then you've spent all that time in arbitration for nothing. It becomes a Pyrrhic endeavor. And so that is why I think that we should confront the potential objections, the impediments, the gray areas, tidy them up, so that third-party funders can also come in with confidence, so that claimants can also tap into third-party funders without the gray area that exists in terms of the potential construction of that relationship. So Joel, I hope you see where I'm coming from in saying that we need to have that regulation, that statutory clarity in place in order to encourage investors in this area.
Thank you very much, sir. So someone else has raised her hand, Bibi Fatuma. Fatuma, can you hear us? Hello, Fatuma. Hello. I think she's off. Hello? Okay. We have another question here in the chat box. They say, does the advocate to the claimant owe any duty to the third-party funder? Does the advocate to the claimant owe any duty to the third-party funder?
That's an interesting question. Strictly speaking, probably not. But the advocate to the claimant will be bound by the terms of the agreement entered into between the funder and the claimant. And so to that extent, if you are advising a claimant and you're its advocate, then you are constrained to honor the bargain that your client, the claimant, has entered into with the third-party funder. Most third-party funders will have their own advocates anyway, in the same way that most lenders in any commercial transaction or relationship will have their own advocates looking after their interests. A funder will have its own advocates who will probably draft or look over the funding agreement, and who will constantly scrutinize the way in which the arbitration is panning out. So it doesn't matter, in the end, I don't think it matters whether we say the advocate to the claimant owes a duty to the funder or not, because there will be a funding agreement which must be complied with, which must be honored, and which the advocate is responsible for ensuring his client honors. So there will also be instances, I think, potentially, where the funder and the claimant are represented by the same advocate. I don't think that's a tidy situation, because it may well be that the funder and the claimant could potentially have their problems midway through the arbitration, or somewhere in the life of the arbitration, and so they need to be represented separately. But funders will have their own advocates, will look after themselves, and I don't think the advocate need owe them any duty.
All right, thank you. We are 18 minutes to the end of the session, so we have another attendee who is asking, who says, thank you for the informative webinar. I see. To what extent do you think being in a committee for law reform can foundational principles of arbitration, such as autonomy of the parties and privity to the arbitration agreement, be modeled to facilitate third-party funding? Is giving an example. For example, can a third-party funder restitute a claimant and take up the claim, essentially inserting themselves in the initial agreement that gave rise to the dispute?
Yeah, that's a very interesting question. I think it is an issue of how innovative we want to be. Insurance law already allows us to do that. Insurance law allows the insurer to essentially pursue a claim in the name of the insured. But the insurance company is the principal, because the insurance company pays off the claimant or pays off its insured and then pursues the other party for the compensation that it paid off. So it is not new to the law. It is not something that we cannot find the mechanism to work. I mean, if I was a claimant, I think it would be a very attractive proposition. If I had a claim that I could not fund myself, and which could potentially take me another 3 years to resolve through the arbitral process, and a third-party funder offers me 60 or 70% of the value of my claim, and then steps into my shoes and pursues the claim in my name, as a claimant, I think that would be very attractive, because I can walk away with the money in my pocket without the various pitfalls that you could potentially face through a dispute resolution process. So, a committee for law reform would perhaps be, and whether it's a committee or whatever, whether it is a lobby, whether it is through the East African Law Society or whatever other body we set up or agree to set up to pursue this, I think we deal with issues such as those because the law has to bend to innovation. There are so many commercial innovations that we are faced with every single day, and that as lawyers we are called upon to facilitate, sometimes without a legal framework in place. And so we have to think about the basic principles of law that we know, and then fashion an instrument to allow our clients to be able to participate in their commercial environment, because we have innovated and we have secured them through our thinking and through our expertise. And I think this is what is called for in an area such as this. It calls for innovation. And in this case, as I've said, I think we can borrow from insurance law and be able to allow third-party funders to, as you say, restitute a claimant and take up the claim. The question, though, becomes whether this should then be made known to the respondent. because obviously the respondent may have various objections to it. A respondent's job is to resist the claim. So as a respondent, you will find any argument available to you to resist the claim. And so without a structure, a statutory, well-known legislative framework in place that allows a third-party funder to, in a transparent manner, step into the shoes of the claimant and pursue the claim, a respondent who discovers this may very well have a viable objection to the way that this is conducted, and which may then frustrate the third-party funder. But as a matter of principle, I can see no objection because it already exists in different facets of law, as I've said. So that could be something that we could tackle as part of law reform. Thank you very much.
Okay, so I think we are remained with 3 questions. There's a question from Usaje. He's saying, thank you so much for your presentation and shared knowledge. He says, he would like to hear your personal opinion about the whole concept of third-party funding. He's asking if it's the right time to embrace the concept. From Tanzania, Usaje.
Usaje, I would not be speaking about it if I did not think it was the right time. I think it is the right time. I think it is something that we need to start to give thought to. I think it is would assist in growing our arbitration community, and would also assist in enabling investors who think that it is a viable environment to be able to enter into that environment. It would also be a very, very forward-thinking way to deal with issues around dispute resolution. In many ways, I think that third-party funding is already happening in different facets, different forms, different mechanisms. And I think that we need to recognize that and put in place regulation so that we can all benefit from it. And so that we can, as I said, grow arbitration as a viable forum or a viable mechanism for dispute resolution, both for those who can afford arbitration, which is considered expensive, as you know, and those who may not be able to afford, but who still want to take advantage of hopefully the speed, the expedient nature of arbitration, the flexibility that it allows, and so on and so forth. So it can be available for small claims. It can be available for all manner of claims that come before our courts today. So I think the time is now.
Yeah, the time is now indeed, Sam. So we are left with just 2 questions from Felix.
Because my voice is fading now.
Yeah, we are now left with only 10 minutes. So he's asking, can the funder lay claim to the cost awarded by arbitrator? That is the first question. Can I read the second so that you can answer the 2 questions?
Yes.
Or we...
Yes.
Yeah, so the first is, can the funder lay claim to the cost awarded by the arbitrator? The second is, will the presence of the funder in the proceedings inform of how costs are assessed? Those are the questions.
Sorry, the second one I don't quite understand.
I think maybe he's asking if the presence of the funder in the proceedings maybe have an impact on how the cost will be assessed. if Felix can hear us, maybe can explain a little bit about the second question. Felix? And I think maybe he's not here, but maybe you can proceed with the first one.
Okay. The question of whether the funder can lay claim to the costs awarded by the arbitrator, I think that's a question for the contract entered into between the funder and the claimant. If I was acting for a funder, I certainly would want to lay claim to a proportion of everything that the claimant is able to recover. I've invested in the claim. I have facilitated the claimant in advancing its claim to conclusion. The conclusion includes an award for damages or whatever the nature of the claim might be, as well as costs. I cannot see any logical reason why I should not lay claim to the costs or a proportion of the costs in addition to the award. So it is a question of what the funder and the funded party contract. But as counsel, if I was acting for a funder, I would certainly include the costs as part of what I would want to recover. Now, if Felix's question is around whether the funder's presence will inform assessment of costs, I do not think that it will inform the quantum of costs, because the quantum of costs depends, of course, on the dispute between the parties, the subject matter, the way the dispute has been conducted, the length of time it has taken, and all the other parameters within which we know costs are assessed. But there is the additional question whether it will influence the question of how costs are to be met. And certainly, if there is a funder, as I said when I spoke in my opening, if there is a funder, the tribunal must be made aware that there is a funder, and the funder must be made responsible in the event of an adverse order for costs against the funded party. Otherwise, you are allowing the claimant and the funded party to have a risk-free ride through the arbitration process. And that cannot be fair. That cannot be a facet of equality of arms. The respondent must be able to know, at the very least, that if it is successful in defending the claim, that it will be able to recover its costs, whether from the claimant or from the funder. So to that extent, yes, there will be some influence as to how the tribunal assesses the costs, but I do not see that it would have influenced the actual quantum of the costs. I hope that helps in answering the question, Felix. Thank you very much.
Well, thank you so much, sir. So we are now at the end of the session, and I think we have covered every question that have been asked. And I take this opportunity to thank Mr. John Ohaga for this insight presentation. And as he said, third-party funding is really an emerging thing that needs to be considered, especially to arbitration practitioners and lawyers in general. So thank you very much, sir, for this, and also take some few minutes to give your closing remarks, and then that will be the end of the presentation.
Well, thank you very much. As always, it has been an honor and a privilege to have the opportunity to speak to you about an area in which, an area for me which holds great interest, which I'm very passionate about. I think that we should all be responsible for sharing knowledge. It is a new and interesting area. I think it has the potential, as I've said, to increase the uptake of arbitration, to make it more vibrant. It certainly is something that is now more and more prevalent in international arbitration, whether commercial or investment. And so I think it is time to introduce it into domestic arbitration as well. Thank you so much for the time that you have spent. Those who have taken their time to listen to me, I really don't take it for granted. I really, really appreciate it. And I really appreciate the questions which have been thought-provoking, have enabled me to think a little more deeply about this area. And I'm more than happy to engage with anybody who wants to talk about it outside of this forum and to put together a think tank so that we can take this issue and other areas of interest forward. Thank you very much to the East African Law Society and specifically to the Arbitration Committee. And thank you, Francois, for moderating this session. Thank you very much. Have a good afternoon.
Okay, all right. Have a good afternoon, and the recording of the session will be shared to all the participants. All right. Bye. Have a great afternoon.